Welcome to Spiedel's California Minute. I'm your host, Catherine Zidane. This week, we're covering when community ends for the purposes of community property laws. For more information on this topic, attend Spiedel's 2-hour community property webinar on October 6th. You'll learn what is and is not community property, how to split community income, and more. To register, go to Spiedel.com and click Webinars. Community property laws play an important role in tax purposes for how income and assets are reported for married taxpayers, tax liabilities, and estate planning, especially regarding capital gains. The termination of community property in community property states can vary depending on specific state laws and individual circumstances. However, there are some general principles that apply across most community property states. Here are some common situations when community property typically ends. When one spouse dies, the community property generally ends. The deceased spouse's share of the community property is then distributed according to their will, trust, or state intestacy laws. Regarding divorce, community property typically ends when a divorce is finalized, but the exact moment can vary by state. Some states consider the community to end when the divorce petition is filed. Others terminate it when the court issues a final divorce decree, or in some states it might end when the couple physically separates with the intent to divorce. In many states, a legal separation, as opposed to just living apart, can terminate the community property regime. Spouses can often terminate their community property rights through a valid written agreement, such as a postnuptial agreement. If a marriage is annulled, it's typically treated as if it never existed, which would also nullify the community property. And some states have adopted the Uniform Disposition of Community Property Rights at Death Act, which addresses what happens when couples move from a community property state to a non-community property state. However, the treatment can vary significantly depending on the specific states involved. It's important to note that the specific rules vary between community property states. For example, in California, earnings and accumulations of a spouse while living separate and apart with no intent to reunite are considered separate property, even if no legal separation has been filed. But in Texas, the community continues until a divorce is finalized, regardless of whether the spouses are living separately. In California, the community ends when the spouses separate with no intention of reuniting. It's not necessary to be legally separated or to have filed for separation or divorce. California Family Code Section 771 provides that the earnings of a spouse, quote, while living separate and apart from the other spouse, are the separate property of the spouse, end quote. For these purposes, living separate and apart is defined as, quote, that condition when the spouses have come to a parting of the ways with no present intention of resuming marital relations. The key question, therefore, is whether the parties' conduct evidences a complete and final break in the marital relationship, end quote. Date of separation means the date that a complete and final break in the marital relationship has occurred, as evidenced by both of the following. The spouse has expressed to the other spouse their intent to end the marriage, and the conduct of the spouse is consistent with their intent to end the marriage. Stay up to date on California tax law changes with a subscription to Spiedel's California Tax Letter. You can get details on this monthly newsletter and download a sample issue at Spiedel.com under Publications. That's all for this week. Join us next time for another episode of Spiedel's California Minute.